Today, we're talking about something pretty wild, a corner of the law where your property can actually be found guilty even when you're not. It's called civil asset forfeiture, and it means the government can take your car, your house, your savings, all without ever charging you with a crime.
So to really get a handle on how this works and, why it's so controversial, let's kick things off with a story. It pretty much perfectly frames the entire problem. I want you to meet Bill Munnerlin. He's an airplane charter pilot. Federal authorities took his plane because one of his clients was only suspected of carrying drug money. Now get this, Bill was never charged with any crime, not a single one. And yet he had to spend $85,000 in legal fees and sell 3 of his other planes just to fight to get his own property back. He almost lost his entire livelihood. Bill's story brings up a huge question, right? How is any of this even legal? Well, the answer is in this really strange legal idea that kind of flips our whole justice system on its head. You see, in civil forfeiture, the legal fight is against the property itself, not the owner. The property is the defendant. It's a totally different beast from what most of us think of when we hear the word forfeiture. And this right here is the key difference. With criminal forfeiture, the government can only take your stuff after you've been convicted. It's part of your sentence. But with civil forfeiture, your property can be found guilty even if you are totally innocent. And I'm not kidding. The case name is literally something like United States versus 2015 Ford F-150. The truck is on trial. And this leads to a really critical point. The whole system can start to look more like it's about making money than about finding justice. The agencies that seize the assets often get to keep the money, and that creates this really dangerous conflict of interest we call policing for profit. Okay, so what's supposed to stop all this from just running wild? Well, in theory, our main shield is right there in the Constitution. It's called the Excessive Fines Clause. You know, for the longest time, it wasn't even clear if this applied to civil forfeiture. I mean, if it's not a punishment, how can it be a fine, right? But then 2 really important Supreme Court cases came along and changed the game. So first, in the Austin case, the court said, hey, these seizures are meant to punish people, so they fall under the 8th Amendment. Simple enough. But then the Bajikajian case came along, and that was a landmark. It's where the court finally laid out the legal test that all the other courts are supposed to use to decide if a fine is excessive.
Grossly disproportional. That sounds pretty solid, doesn't it? The punishment should fit the crime. Makes perfect sense. But in the real world, well, those 2 words have turned out to be a massive, massive loophole. And this is really where that constitutional protection starts to fall apart. A standard that sounds great on paper has become, well, vague and murky out in the real world. So, did this test create a clear, consistent standard? The short answer is a big, fat no. Lower courts have been all over the map trying to apply it, and the result is just a confusing mess. So instead of getting clarity, the Supreme Court's vague rule led to this patchwork of inconsistent tests. I mean, look at this. Different courts are using totally different methods. One circuit court even complained about the murkiness of its own test. It basically makes justice feel like a lottery. The outcome really just depends on where you happen to live.
So, how effective has this test really been? Get ready for this. In the first 15 years after that big Bajikajian decision, federal appeals courts found a forfeiture to be excessive just 4 times. 4! Out of thousands and thousands of cases.
So what's the real takeaway here? The main constitutional safeguard we have has pretty much failed to protect people from these insane seizures. It's a standard that just has no teeth.
So you have to ask, is there a better way? What if we could create a formula for fairness? A proposal from the Harvard Law and Policy Review suggests exactly that, an objective, mathematical solution to this very human problem. The idea is, instead of arguing over vague words like grossly disproportional, we could use the super detailed analysis that the U.S. Sentencing Commission has already done to measure how severe a crime is and what its punishment should be. The whole idea is to create a clear, predictable starting line for everybody. The formula just translates the seriousness of a crime, which we measure in months, into a hard dollar amount. Let's see how that actually plays out. So let's say a crime is serious enough for a maximum of 24 months in prison. This formula sets a clear limit,
$36,000. Anything above that is automatically considered excessive. And here's the crucial part. This flips the burden of proof. The government would have to argue why a bigger seizure is fair, instead of the citizen having to prove why it's not.
You know, this idea of protecting a person's ability to just survive, it isn't some new radical concept. It actually goes all the way back 800 years to the Magna Carta. The whole point is that a penalty shouldn't be so devastating that it completely ruins a person's life. But today, our own courts can't even agree on whether that ancient wisdom matters. And this is just wild. It shows you how arbitrary the system is. In one part of the country, a court will actually consider if taking your property will destroy your ability to make a living. But in another part, that factor is totally off the table. A clear formula could fix this, and you could even tweak it to factor in someone's income to make it even fairer.
All right, let's bring it all home. Why does any of this matter? What is the big picture here?
Adopting a clear standard like this could totally change the game. It would bring predictability and fairness to a system that, right now, is just murky and often devastating. It creates clear guardrails. And maybe most important of all, for a truly innocent owner whose offense level is 0, the formula calculates the only just amount of forfeiture, $0.
And that leaves us with the big question. It's really at the heart of this whole debate over the Eighth Amendment and what it means today. The answer is going to decide whether our property rights depend on clear rules or on the random whims of a broken system,